audience.
That L was supposed to be at the top. Good morning, everyone.
Morning.
Nice to be presenting to such a full classroom. But this morning I am going to be presenting on the continental shelf. I just started by giving you an idea of the mass of water that surrounds the Earth. That is why such emphasis has been placed on, the laws of the sea. So first we're going to start off by a definition. So,
Yes.
all right, thanks. We're going to start off by looking at a definition of what we mean when we talk about continental shelf. Now, when you read the definition, there are some areas that I have underlined. The continental shelf really comprises, the continental shelf really comprises of the seabed and subsoil, and it is throughout the natural prolongation of its land territory to the outer edge of the continental margin. I have a diagram that would further explain that aspect of the definition for you. It covers up to a distance of 200 nautical miles from the baseline. These are the areas that I'm going to focus on when I'm talking about the continental shelf. I'm going to look at Article 77, which really speaks to the rights of the coastal state over the continental shelf. Article 78, that talks about the legal status of superadjacent waters and airspace and the rights and freedom of other states. And Article 83, which speaks to the limitation of the continental shelf between states with opposite adjacent states. So here we have a diagram of the continental shelf. This is your baseline here, and this is where the continental shelf is. Before, in our previous lectures, we spoke about the exclusive economic zone. We are familiar with the territorial sea, contiguous sea. So this is where I will be focusing on today, and that's the continental shelf. And within this area here, we have the high seas and we have the international airspace. So just a diagram to give you an idea of what I mean when I'm referring to continental shelf. So first we're going to look at Article 77 and what Article 77 speaks to. It talks about the rights of coastal states over its continental shelf. And Article 77 covers three areas, well actually 4 areas. I haven't outlined them all on the board, I haven't outlined them all on this slide, but these are the 2 areas I will be focusing on in terms of looking at Article 77. So to just give you an idea of what the rights of the state, the rights the state has over its continental shelf, I'll just read out the 4 areas. The coastal state exercises over the continental shelf sovereign rights for the purpose of exploring it and exploiting its natural resources. The rights referred to in paragraph 1 are exclusive in the sense that if the coastal state does not explore the continental shelf or exploit its natural resources, no one may undertake these activities without the express consent of the coastal state. The rights of the coastal state over the continental shelf do not depend on occupation, effective or notional, or on any express proclamation. The natural resources referred to in this part consist of the mineral and other non-living resources of the seabed and subsoil together with living organisms belonging to sedentary species, that is to say, organisms which at the harvestable stage either are immobile or on or under the seabed or are unable to move except in constant physical contact with the seabed or the subsoil. So that is what Article 77 speaks about. Now the 2 areas that I'm going to focus on from Article 77 is 1, which speaks specifically to the sovereign rights that the coastal state has over its seabed in terms of exploring its natural resources. When we think about natural resources, in the seabed, we are talking about minerals and other non-living resources of the seabed and the subsoil together with living organisms belonging to sedentary species. And that is basically to say that we are talking about organisms which are either immobile or under the seabed, or unable to move excepting constant physical contact with the seabed or the subsoil. So this definition.
Can you give us some examples?
Yeah.
Like that?
Yeah. Okay, this definition, Mr. Francis is right. This definition implies that organisms which cannot swim that belong to the sedentary species may include stuff like corals, oysters, including pearl shells, sponges, and plants. Now, it was interesting in terms of my research, there was this whole conflict between crabs and lobsters. Some say that there is a controversy in terms of trying to put crabs and lobsters to fit into which, aspect of sedentary species it belongs to. So, according to one view, it says that lobsters swim and crabs do not, and hence crabs are within the meaning and lobsters are not, right? So basically what it's saying is that lobsters can swim, so they move, they don't belong to one state doesn't really have sovereign right over the lobsters. So the lobsters could be on your seabed and then, see another lobster and then try to follow the lobster and goes to another seabed. And crabs, well, they stay permanent, so the state has sovereign right over crabs. Yeah. Anyway, continental shelf, moving on. So we are going to look at Article 78 now, which speaks to legal status of superadjacent waters and airspace, and rights and freedoms of other states. Again, in looking at Article 78, there are two areas. I can read it out for you and then I will explain my perspective on it. So, Chapter 1 looks at the right of the coastal state over the continental shelf do not affect the legal status of the superadjacent waters or of the airspace above those waters. The exercise of the rights of the coastal state over the continental shelf must not infringe or result in any unjustifiable interference with navigation and other rights and freedoms of other states as provided for in this convention. So we see here that the coastal state has sovereign rights or legal status over its superadjacent waters. No, sorry, it does not have legal status or right over its superadjacent waters and the airspace above those waters, right? So the domain, as we saw in the definition before, the domain that really embodies or encompasses the continental shelf is really the seabed and the subsoil, and not really the sea waters. So when we think about superadjacent waters, we are thinking about, I have a diagram that will further explain this. The superadjacent waters really covers, it falls within the 200 nautical miles from the baseline, and it's all part of the domain of the EEZ, whereas those beyond the 200 miles are the regime of the high seas. Right? And this is what we're referring to here. So this part here, correct me if I'm wrong, Mr. Francis, but from what I understand, this part here is really the high seas. And
but you have it in the diagram.
Yeah, this part here is really the high seas.
Anything beyond 200.
And yes, so anything beyond that, nobody could say that they have a legal status or legal rights over it.
But within the, stay from the diagram, within the 200 miles.
Right.
So
yes. And the international airspace as well. No one can say that they have legal right over the international airspace. So when we talk about superadjacent waters, that is what I'm referring to.
Just to confuse it a bit, within the 200, even the submarine area, within 200 miles, that will also be exclusive economic zone.
Yes. So,
okay, Samantha?
All of this.
And the yellow continental shelf is also part of the exclusive economic zone because the exclusive economic zone sits in both the water column and the submarine area. It's continental shelf, it's also exclusive economic zone. So they run side by side, except if you're well endowed geologically, you can go beyond the 200 miles. That will not be exclusive economic zone. No, just continental shelf.
Exactly. Yeah.
Broad continental shelf.
Everybody understand?
Well, not yet, but why didn't they probably just say exclusive economic zone? In other words, then, seeing that exclusive economic zone, we're taking both the water column and the submarine area, the continental shelf, in a geological sense. Why couldn't we just have one exclusive economic zone? Because they both are about resources. So why couldn't the continental shelf have been subsumed under the exclusive economic zone?
I was thinking about that when
Yes, it's
I
not
was
something
doing
everybody
my
has to think about.
I was
Yes.
thinking about that when I was doing my research as well, because
Did you come up with anything? Were you able to come up with anything?
Yes, but what I realized is that I think they wanted to be very specific in terms of defining the exclusive economic zone and defining the continental shelf, because when you go back into the history, it created a lot of conflict. So I think in terms of understanding maritime boundaries and making the definition between what continental shelf entails, that is one of the reasons why they sort of categorize it in terms of understanding continental shelf, what each state has sovereign rights over, and then in terms of exclusive economic zone. That's the only.
Well, added to that, of course, is that remember the continental shelf was there before
Right.
exclusive economic zone. But you use two criteria in determining the outer limit of the continental shelf. You use a geological criteria up to the edge of the continental margin. Into. You also used a distance criteria.
Right.
As far as distance is concerned, yes, exclusive economic zone and the continental shelf run side by side. However, it is quite possible you have a few states in the world whose shelves would go beyond the 200 nautical miles.
Yeah.
Not many of them.
Yeah.
A few of them. And those few states, if you had just said, well, everything is subsumed under exclusive economic zone, they would have lost rights which they previously had. And nobody is going to give up rights it's not willingly that you previously enjoyed. So therefore, you say, well, we have to keep continental shelf, because there are some states that can go beyond the 200 miles. So you have to accommodate that.
Yeah.
And they say, well, all right, if you can go beyond 200 miles, so be it. If you're well endowed by nature, you can go up to 300 miles.
Yeah.
Beautiful. But, so for those states, you have to accommodate that.
Okay.
Good morning. Good morning, Norman. It's nice having you.
So, just to give us an idea of the measurements as it pertains to maritime zones and boundaries, you can see that the territorial sea covers up to 12 nautical miles, the contiguous zone, and another 12 nautical miles, the exclusive economic zone. That was implemented in 1982, covers up to 200 nautical miles. And there are some cases like Mr. Francis alluded to there, where you have an extended continental shelf. And that goes up to approximately 350 nautical miles, or 100 nautical miles beyond. It's 2,500 miles isoband.
Give them a minute and then take it in.
Yeah.
Got it? Everybody? Lloyd? Luana? Samantha? Yeah? Well, yes, some of these terms are very technical. It doesn't really matter too much. Well, the important thing is that it's the distance there,
Yeah.
the depth of 2,500 meters isoband. We're looking at the depth. We're looking at the yes. This deals with depth. So, territorial sea, did already. Contiguous zone, we say 12 nautical miles. The contiguous zone, it's good to keep the distance. Continental contiguous zone is really 24 nautical miles.
Okay.
But I know why you put, I know why you're saying 12. It's 24. But 24 nautical, and remember, always we are measuring from the baseline. So it's 24 nautical miles from the baseline. Well, you're right, because the first 12 would be territorial sea.
Yes.
And then the other 24 would be. But always express it in those terms.
Okay.
24 nautical miles, which I must say measured from the baseline. We're not measuring from the outer edge of the territorial sea. We are always, all these distances are measured from the same baseline. When we are doing territorial sea, we spoke about the construction of the baseline. And we continue with it, going into exclusive economic zone, into continental shelf, into contiguous zone. We're taking our measurement from one point,
Okay.
the baseline.
Okay.
Yeah.
So that the continental shelf is not sure that the nautical miles or 100 nautical miles beyond 2,500 miles ice so far. What happens at 3,000 miles? Is it that it will, my question is after that, yeah, what happens?
So,
After that is a deep sea.
yeah,
Deep sea, yeah.
and that's a different area.
So after that, now
That's when it becomes the natural heritage or whatever.
the common heritage.
Yes.
Yes, yes. So in a sense, it's two things there. You could have a neighboring state in your nation, but you could also now, the boundary could be with the deep sea there.
Alright.
Because the shelf has extended so far out, yeah, that question is, the shelf ends at this point, this is what they're saying there. Yeah, it's specific, 250 nautical miles, or sometimes they have maybe the depth criteria. So, but beyond that is the deep seabed, as you say, the common heritage of mankind, which nobody, no state has exclusive right over that. They have a special regime, huh?
So then that also forms part of the high seas, in a sense.
Only waters above them will be high seas. The waters above them will be high seas. Anything beyond 200 miles, waters are high seas.
So now we move on to Article 83, which speaks to the limitation of the continental shelf between states with opposite or adjacent coastal states.
Madam Taliaka,
So again, I
why have you gone so far away?
focus on two areas, but I will read out the four parts of the article, the four chapters of the article for you. The delimitation of the continental shelf between states with opposite or adjacent coasts shall be affected by agreement on the basis of international law, as referred to in Article 38 of the Statute of the International Court of Justice, in order to achieve an equitable solution. 2. If no agreement can be reached within a reasonable period of time, states concerned shall resort to the procedures provided in Part 50. 3. Pending agreement as provided for in paragraph 1, the states concerned, in a spirit of understanding and cooperation, shall make every effort to enter into provisional arrangements of a practical nature, and during this transitional period, not to jeopardize or hamper the reaching of the final agreement. Such arrangements shall be without prejudice to the final delimitation. And where there is an agreement in force between the states concerned, questions related to the delimitation of the continental shelf shall be determined in accordance with the provisions of that agreement. So, when we talk about delimitation, we're talking about the continental shelf between states within the opposite or adjacent states, and it shall be effective based on the agreement outlined in international law. And this agreement is implemented in order to provide some sort of, if there are disputes, in order to provide some sort of equitable solution. However, there are cases where if an agreement cannot be reached within a specific or outlined time period, the states concerned can resort to procedures outlined in Part 15, which speaks to how settlement or disputes, when you're talking about maritime boundaries, can be settled. Right? When you think about delimitation, I was just looking for what you call it, a definition that kind of helps us to understand what I mean when I'm speaking about delimitation. So I went back to Article 15, and it gave us a sort of definition where it speaks to where the coasts of two states are opposite or adjacent to each other. Neither of the two states is entitled, failing agreement between them to the contrary, to extend its territorial sea beyond the median line, every point of which is equidistant from the nearest point from which the breadth of the territorial seas of the two states is measured. So, this speaks to sovereign states, and it also speaks to landlocked states, and which we have covered, I think, when Vishal and Risa, as well as Amanda. Yeah. Okay. Go ahead, Mr. Francis.
Well, isn't any difference between this provision and your Article 83?
What's the difference?
This is the limitation regarding the territorials.
Right.
There isn't any difference between that and the Article 83, which you have just cited. No? Well, not just you, but anybody else. Article 83. What is present
In this one.
in this one that is not present in 83? And I could add 74, because 74 and 83 are the same, mutatis mutandis. 74 is dealing with the exclusive economic zone. 83 is dealing with the continental shelf. And it's almost like word for word, isn't that correct? Yes, continental shelf and exclusive economic zone. The wordings are identical. You just have to take out exclusive economic zone and put in continental shelf. Mutatis mutandis. But in the territorial sea, what have we seen?
What I liked about this is that it actually.
What you like? Okay, let me hear what you like about it.
Okay, but it actually expressed in writing how settlements are measured in terms of looking and re-measuring it from territorial sea and the median line. I also spoke to the equidistant from the nearest.
This is referring us to a median line, which is a method. The first thing that comes to Luana's mind when you delimit this median. So what that's the fairest thing? You get the median line, equidistant. Am I reading your mind correctly, Luana? It's a dangerous thing. Yes? So, but this is the first thing that comes to my mind. It comes to even if Laurie doesn't want to admit it, that's what comes to mind, to the median. Why couldn't they just say the median line? As we have it there, it can't go, it should be the median line. Why are they saying that with respect to the exclusive economic zone and anything? No, they didn't give us anything at all by way of method.
Right.
So how do we commence? How do we begin? Because all this pointing us to, you do it by agreement based on international law. The agreement should be based on international law, as identified in Article 38 of the Statute of the International Court of Justice. We already know that.
Yes.
On the sources. And it went on to say, in order to arrive at an equitable. So in a sense, it's as though the emphasis there is on the result. Equitable. Something that is fair. Something that is just. Something that is reasonable. But how do we get there? How do we achieve that solution?
Right.
This thing, this provision is silent, it's clear. If we compare Article 58, sorry, not Article 58, Article 6 of the 1958 Geneva Convention on the continental shelf, we would see reference to method. We would see median line. We would see equidistance, median with respect to opposite states, equidistance with respect to adjacent states. Article 58 has it. By the time we get to the 1982 convention, there is no reference to method.
Right.
This is heavily influenced, this provision, heavily influenced by the decision in the North Sea continental shelf cases, where the court said delimitations should be in accordance with equitable principles for the first time. So by the time they were drawing up this 82 convention, they had the benefit of the thing. But the reason again was the median line would in most cases probably give you a fair result. But in some cases, depending on the geographical characteristics of the area that we are attempting to delimit, median line could lead to unfair result. Where an area of shelf, a common shelf, a far greater part of it could be accruing to one state. But you don't want that, because there are times when we have to look at the special circumstances which may exist that could suggest we should in some way modify this median. So that is why they didn't want, because you see conditions, circumstances vary from place to place. And that's why they didn't want to give you a hard and fast rule figure. And the greater the area of shelf, if you have these irregular circumstances, the greater the distortion, the degree of distortion that could be created. And you don't want that. And that was a problem in the North Sea case, where Germany, who have a concave course, was in the middle, in between Denmark to the north and the Netherlands to the south. If they had used equidistance, as Denmark and the Netherlands were arguing, the area of shelf accruing to Germany would have been considerably less than that which would have accrued to Denmark and the Netherlands. It would have borne no relationship to the length of the coastline. And the court in that case said, yes, this is a relevant circumstance. This should be taken into account. Some degree of proportionality between the coastline, the length of the coastline, and the area of the ship, among other things. Yes?
Yes.
Yes? Yes? Claire?
Yes.
Claire? Laurie?
Yes.
Okay.
So
Thanks a lot for having setting it up.
No problem.
That's helped Samantha a lot. She'll be eternally grateful to you.
So in terms of looking at limitation again, what I looked at is how we go about negotiating single maritime boundaries. So like Mr. Francis said, well, I don't know if Mr. Francis said that, but anyway, Article 83. When in my research, I saw that it was sort of identical with Article 74, which deals with the limitation of easy, right? So the advent of easy has sort of encouraged states to negotiate for single maritime boundaries, that is, boundaries which serve to demarcate or differentiate for maritime zones, including some cases the territorial sea.
Let me comment on that.
Okay.
Yeah, the one line. Well, yeah, it's a single line. Let me hear your comment on that. You think it's a desirable thing to have one line? In other words, the one line meaning you use the same line you're using for the waters, you're also using for the submarine area.
Yes.
So one line.
Yes.
You think this is desirable?
Yeah, and in terms of reaching some sort of equitable solution, I think that is a practical approach in terms of using that one.
Yeah, the nature of the rights is the
Yeah.
same.
Yeah,
And indeed, if you say you have one line for the submarine area
yeah,
and another line for the water column,
yes,
it creates a lot of confusion.
exactly.
Because essentially, the rights in both cases are resource oriented. They are resources. So let us have a single line.
Yes.
So even if the dispute may be arising in, let's say, continental shelf, we're exploiting for line for oil and natural gas. But let us have let us agree on one line. Yeah.
Right. Everybody understand? Any questions? No? Okay.
Sarah, you're happy?
127.
Okay.
Go ahead.
All right, sure. Sure, you're welcome. So we have all these. In my research, I realized that maritime boundary, continental shelf, EEZ creates a lot of conflict, right? And I guess, as Mr. Francis said, it's because of the natural resources and the whole aspect of sovereignty over the continental shelf, the EEZ, however you want to
I
frame
don't
it.
want. I never like to hear you say sovereignty over continental shelf.
Well,
Sovereign rights.
Sovereign rights, yes.
Sovereignty is with respect to the territorial sea.
Yeah.
If you don't remember anything,
Remember that. So there are a lot of legal means that states utilize whenever they're trying to negotiate if there are any conflict. And there are different negotiations that lead to treaties. We're familiar with that because of even Trinidad. We have entered into a number of treaties with countries like Grenada, like Venezuela, Barbados. And my reading, I saw you wrote an article about that as well.
Barbados hasn't so much a treaty. And I'm glad you said that
Yeah.
because with respect to Venezuela,
Yeah.
we have the treaty.
Mm-hmm.
In other words, and we were able to achieve it through negotiation.
Mm-hmm.
Venezuelans and the Trinidadians sat around a table and they were able to agree on a line of delimitation, line of demarcation. Similarly, more recently, Grenada and Trinidad were able to sit around the negotiating table and agree. In the case of Barbados, they were not able to resolve the issue by negotiation. So there was a dispute.
Okay.
There wasn't a dispute with respect to Grenada.
Mm-hmm.
Well, there was a dispute, but at least even if there was a dispute, they resolved it through negotiation, face-to-face negotiation. In the case of Barbados, of course, you always begin with negotiation,
Right.
but they could not resolve it. Bajans and the Trinidadians couldn't, through their own effort, agree on a line. So there was this dispute, remember? And then, but luckily, they agreed to submit it to arbitration.
Yes.
And that's why you come to Part 15, because
Yes.
Part 15 now provides for you a number of different methods which could be used in settling their settlements.
Yes.
So they actually went to arbitration,
Mm-hmm.
and the tribunal met, and then the tribunal, they made the submissions, so Trinidad made the submission, Barbados made the submission, and finally, the tribunal said, okay, this is how this line is. Listen to both parties, and then determine. Maybe not going exactly to what either party was saying, but deciding, okay, we've heard you, I think this is a land.
And some of the other methods, arbitration, adjudication at an international court or tribunal. Courts and tribunals have also played a major role in terms of maritime delimitation.
So you see, it gives you a number of different means,
Yes.
not one.
Yes.
And you may prefer one as against the other. In the case of Trinidad and Tobago and Barbados, it was arbitration.
Yes.
Arbitration meaning that you agree to set up a tribunal. The two parties, in that case Trinidad and Tobago and Barbados, will agree on the composition. Who should sit on the tribunal? Trinidad would select one member, Barbados would select another, and then the two of them would agree on a third, who would chair the thing. That's right. In the case of adjudication, see, arbitration is an ad hoc arrangement. Adjudication, if say for example is the International Court of Justice, the court is already there, which probably could cost you less than the arbitration.
Yes.
Because the court is there in The Hague, let us send it to the International Court of Justice. But under the Law of the Sea Convention itself, under 1982, a tribunal, a Law of the Sea Tribunal, is established. Yes, it's in Hamburg, Germany somewhere. is established to consider disputes arising out of the 1982 convention. You see, it's a standing body too. You don't have to pay them to it, you just have to pay your lawyers and so on. But because the tribunal is already there. So quite apart from the court, the International Court of Justice, you also have a law of the sea tribunal. So people in a sense can specialize.
Is it the tribunal legal man?
Yes. It's legal means, that's right, yes. Okay, because if you send a dispute before the law of the sea tribunal, it would be determined on the basis of law. Through the application of legal, yes, they all are lawyers. And remember, of course, that method, of course, you can have winner, you can have a loser. The matter will be determined through the application of legal principles. Laurie, let the chips apply the principles, let the chips fall where they need. But of course, clearly as you know, they will take into account factors of equity. They will try to ensure that the result is fair, something that the parties will be able to live with. If you have irregular features, unusual geographical circumstances, they will take all these things into account. But one final thing, I'm going to read the cases, what you will see, although in 83 and 74, they have not pointed us to any method. What we have been seeing with respect to some of these decisions, tribunals, or in the law of the sea, tribunal or the court, they start, you have to begin somewhere.
Yes, yeah.
Samantha, you have to begin somewhere. And they often begin with maybe equidistance like median line. Yes? And then having done that, and look to see how the areas could be parted. Say no. Maybe there's a disproportionate amount going to this part. So then they would say, well, all right, we therefore will have to modify. Yeah?
Yes.
Modify this line so that we can get a fairer result. Which in the end is what 84 is asking you to. The solution must be equitable. Hence the reason why they would necessarily have to modify the line if a disproportionate amount of the shell, the area to be delimited, is going to one party after the other. Yeah? They have helped us considerably in telling us the beginning.
Yeah.
Whereas 74 and 83, they already do tell us how to start.
Yeah.
But in the practice now, how the tribunals are doing it. So we have a much clearer idea now of the streams. Yes, Ms. Gill.
Let's say one party feels at the end of the tribunal that the outcome is not an equitable one. Can they agree to another method that's to take?
Good question. Good question. Once you have submitted a dispute to arbitration or to the court, the decision is final and binding. That is the essence. If you don't want a decision that is final and binding, don't send it to arbitration. Don't send it to the court. This is why we have this problem with Venezuela and Guyana. This matter was submitted in the 19th century. In 1897, the matter went before arbitration. By definition, the award is final and it is binding. No appeal. Ms. Guerra? No appeal. So clearly you would think that once the award has been made, that is that. The matter is settled. So how come today Venezuela is still saying that there is still a dispute? This is why they would never agree to submit it anyway, even if they say there's a dispute, to submit it to any court, because the court will say just that. You already submitted it. This is final and binding. This would have been the understanding of both parties. You would abide, Ms. Guerra. It's as if we go to court. Okay, we can appeal and appeal and appeal, but once we reach the final court of appeal, that's it. You were saying the land is yours, no, it's mine, it's here. Okay, good, let's go to court. Yes? We would have our day in court. At the end of it, the court would say, no, it belongs to me. So you get no land. Yes, Ms. Guerra? And it's the same thing at the international level. This is why you can have a winner going to court or to arbitration, a winner and a loser. If you're negotiating or if you have mediation, you can make, as they put it, or this, you can have a win-win situation. Try to make some concessions to you, we try to make some concessions to you. So we could both leave feeling pretty. I didn't lose, you didn't lose. But for the sake of peace and so on, to have the matter resolved once and for all, I made some concessions. You compromise. We agree mechanism. But when you go to court, does this bottle belong to me? Does it belong to you? The court will have to say something. Okay, I say, okay, it's my bottle. How come it's your bottle? Well, Ms. Guerra sold it to me. So, my bottle, what should I say? So, no, the bottle stolen property. It belonged to me. Yes, sure. Huh?
What's the proof you only want?
Well, you're quite right. And of course, yes, a question of fact. So I would have maybe have idea. Okay, where did you write? I bought it down there. Look, here's my pen. That's the evidence. Yeah? That's the fact. Now, if I don't have that in my document, but maybe Ms. Guerra saw me by this thing. And she saw me put it what? She's my witness. Come, Ms. Guerra, take the stand. Yes? And she can testify, yes, I said. But you're quite right. If I don't have that clear evidence, well, put it this way. As a court, put my case at you would have to look at me, look at you, and try to determine which one we think is speaking the truth. But you see, if I'm saying it's mine, it's mine, it's mine, the burden of proof is on me. The burden of proof is on me, not on the other. Because I am the one who says it's mine, it's mine. So he who asserts must prove. So the burden of proof will be on me. And this is what is good about my decision. Look, I judge you, you don't have the evidence. So what do you think you're coming to? You know you're coming to court? Yeah? If you look at it, look at the program now, Samantha. Or you don't look at it. You've seen it sometimes, but sometimes in some cases, some people go unprepared if you like. That is one thing in America. If you see, they have files and files. Facts are important. You don't just apply the law like that. You first of all have to establish the facts. And this is something we probably can learn. In our case, galleries and so on. But it is useful. It is telling you, if you're looking at it, one of the things, lessons you should draw from it is how well prepared some of these people are. They have everything. What everything is in the evidence. And Bird goes, Bird picks up the document, gives it to Judge Judy. No, it is just, you have to have the, but it shows you this is that you see, they believe in litigation. They know that everything that they do, every transaction could involve litigation. So they have kept all the bills, all everything. We are not as litigation minded as they are. So yeah. What did you, I had a thing that's written there in bill or something. So they probably keep Samantha, when you're going to buy your stove or you're going to keep the bill for some time. Yes? Yes. In the event, who knows what can happen? How do I know you bought it? If it's a lease, do you have a copy of the lease yet? What if you know you're going to put a letter in the lease? You have to bring the lease. You have a contract. You have to observe to. In many cases, they put contract in writing. We tend not to. But show me the contract. Here is the contract. These are lessons for us. Samantha, in some things, especially if it involves a lot of money, put it in writing. The law may not necessarily say the contract has to be in writing, but it is good to have it in writing in the event that there is. Because it's you say, it's no one else. It's no one else saying, it's you say. No. Have it in writing, especially if it involves, very small money. But very often it's worth your while. Even if, strictly speaking, the law has to be in writing. But in the event that there is a dispute, this is what we agree to. Yes, Samantha? Yeah. So don't go with anything, buying anything, major thing. It's putting out thousands of dollars. And this is just your word against the other person's. put it in writing and keep the contract. Marina, you missed a good lecture.
I know, I'm sorry.
So, Mr. Francis, just to go back to the delimitation,
Yeah.
in Article 15 for territorial seas, they actually put the method, they actually stated the method median.
Median, that's
But-
right. They say
but for the
honest,
easy-
they said that's right. No
For the
reference.
easy and for the continental shelf, it was just equitable solution.
That's right. No reference to any method. And as I told you too, in the 1958 Geneva Continental Shelf Convention, 1958 Geneva Convention on the Continental Shelf, Article 6. Forget the convention and look at Article 6 of that convention. You will see the spirit of agreement. If not, the median line regarding opposite states or the equidistance regarding adjacent states. Unless, that's what Article 6 says, unless there are special circumstances. Unless there are. So he didn't just say median line, he said unless. So it is median line together with special circumstances. And in a sense, all pointing to the fact that we're trying to arrive at this equity. If there are special circumstances, we again will have to make some changes. Yeah?
That's from 1958 when they came forth in 92, they just left it out. They
By
just
1992, we just left it.
just said equitable.
I think they were largely influenced by the North Sea continental shelf.
Okay.
This whole concept of the natural prolongation. This is what the quote said in the North Sea continent. The continent is a natural prolongation, the concept of natural prolongation. It's just like the land. Sorry to take up so much.
That's all right. So that is why, as Mr. Francis alluded to, that's why many states avoid litigation because it's final. So whatever the outcome is, whether you're happy with it or not, that's it. So that's why most of them always try the first route use, which is negotiation, and lead into some sort of treaty. If there is no agreement, then most states go through the process of litigation. Or last one, which I saw and I found that it was interesting to include just accept equal disappointment. Right? So everybody may not be winners, but there is some sort of equitable solution. You may not leave the table feeling like a winner, but you got something sort of substantial from it. So everybody is equally disappointed and like so.
Am I allowed just to add it? Let's make a set of yeah. Delimitation is extremely important because if the parties cannot agree, it means that there is a dispute. If there is a dispute, you would not be able to attract any investment in the area because the investor would know, the company, our company, probably would be taking a lawsuit. You must have, this is why countries, this is so important, especially if you have reason to think that you are natural gas operators, to have this issue regarding the boundary settled. Because if you don't have it settled, then you will not be able to conduct any activities. You will get the other state protesting, and of course the investor doesn't want to be caught in the middle between the two of you. So you're setting the boundary. And just as in your own property, the domestic level, good fences make good neighbors. Build a fence. Don't just let the thing just like that there. Because if you are a troublesome neighbor, probably might be encroaching. Or maybe in any event, maybe his dog is just running into your yard, blah, blah, blah. Good fences, Taniaka. Good fences make good neighbors. Similarly, you have boundaries settled, then there's one problem of the head between the settled and the neighbor. Where your area ends and that of the other party begins. Sometimes countries go to war over a line of the limitation. You don't want that anything. I try to resolve it, of course, by peaceful means. So Barbados, Trinidad and Tobago, they agreed. They couldn't agree through negotiation, but eventually they said, let us find some peaceful means of settlement.
Yes.
And they went for arbitration. Can I say
Yes.
that? Well, all right. Well, okay, yes. Now what next? How do you want to decide something?
Email?
Email it to you. Okay.
Yes, yes.
All right.
Yes,
Well, you
I
can-
think
we have a
I
site you can
email
go
it
to.
everybody.
What,
We have a site you can go to get it.
what's the site?
Ask Jerry. Jerry can give you the site.
Type in sites
The site that they can go
for
and get
to view this.
to view this.
Oh, there's a YouTube view.
It is
But
on
you will also get the slides. You email me the slides.
Okay, so I can check it on YouTube also.
Yeah, so we'll talk after.
Okay.
So you see we up to date.
Yes,
More than
I
Chrysler?
so.
That's right. Thank you very much. Thank you very much.
You're welcome to access anytime.
Okay.
So I will send it to everybody. Don't worry.
Thank you very much.
Everybody will get a copy.
I'm going to introduce I'm going to introduce to you 15 minutes and then we'll take a break. We move from anything on the law see the technology
No.
wants to raise.
I think the dog is very interesting.
Anything on the law see the technology would like to raise. Speak now or forever hold your peace. Anything, anybody? Rita, what is ready?
Oh, she had her car stalled in midst of town, so she had to get a tow truck to come and tow it away. Yeah,
This morning.
this morning, yeah. I know we're here. And I was gonna pass for her, but she has a class after and then she has to leave immediately. So
Okay, okay.
yeah, she's supposed to be. She should be coming sometime soon.
Well, you will let her know that I asked for her.
Yes, I would definitely do that.
Yes, because I didn't see her last week either.
Huh?
I didn't see her last week either. We move to the acquisition of title. And well, let me begin with territory. Title for territory. Now, first of all, the significance of territory in international. Well, we have to do territory. Okay. Roina is saying, well, why do we need to? Because there are no more lands to be conquered, no new lands to be discovered. Just about everything to be discovered has been discovered. So why are we talking about this tightening to territory? Can anybody suggest why do you think that can be important? Or just wasting your time?
Well, there are still
just do this chapter in the text.
but there are still land disputes even now with regards
That's
to
right. That's right. As you know, there are still disputes. And some of this disputes, the origin of these disputes goes sometimes centuries back. So it is still important to familiarize, to learn those old rules that you might have had regarding the acquisition of title to territory. You are aware, for example, that you have a territorial dispute between Guyana and Venezuela, between Guatemala and Belize, between Britain and Argentina over the Falklands or Malvinas Islands. And you have others, I think, between Bolivia, within this hemisphere, between Bolivia and
Peru.
Peru. Yes. Quite a number. Yeah, you have, these are some of these disputes.
So what if you got Guatemala and Belize?
Yes. Yes. As a matter of fact, I'm not too sure exactly what the situation. At one time, Guatemala was killing all of those. Exactly. I think they have since modified the claim. I don't think the boundaries are there. Another thing, of course, is this. In international, you speak of sovereignty. Some of the important principles that you become accustomed to in international law and international relations are inextricably linked to territory. You speak of sovereignty. Trinidad and Tobago is a sovereign, independent nation state. But one of the reasons why it is so is because it has territory. What if it didn't have territory? land. They are Trinidad and Tobago's territory. Yes. That is what makes it a state. In an international law, you cannot have a state if you don't have territory. Entity must have territory. So, for example, you follow the Kurds, you know them nowadays in the news. Some of them are in Syria, others in Turkey, there have been some in Iraq. There are people. They're not Arabs, they're not Iranians, they are Kurds. But they do not have a territory they identify as their own. They're in other people's country. That is why you can't speak about a Kurdish state. The Palestinians, they are people. They're not Lebanese, they're not Syrians, they are Palestinians, not Jordanians, scattered all over the place, in the Middle East. Some still living in refugee camps, poor people, Palestinians. But they do not have a state. As a matter of fact, this is one of the funny issues regarding the resolution of the dispute with Israel. Recently, the US has been saying a two-state solution. So you have Israel and Palestinian in the West Bank and in the Gaza will have their state. Very viable, but the fact is that they do not have a state. That is extremely important. Speaking of state territory is important. Speaking of sovereignty that you exercise, speaking of jurisdiction, within here, Trinidad and Tobago, the Parliament passes laws applicable within the entire territory of Trinidad and Tobago. From Caucus down in the southwest to Togo up in the northeast, from Guayaboyari in the southeast to Chagaramos in the northwest. The laws of Trinidad and Tobago are applicable within this jurisdiction. If you do something wrong, you can be taken before the courts of Trinidad and Tobago, because Trinidad and Tobago's courts can exercise jurisdiction. Another thing, of course, is also linked to nationality. The laws of Trinidad and Tobago say if you are born within our territory, you are a national or a citizen of Trinidad and Tobago. So for all these reasons, territory is important in international law and international relations. That's a significance. Any comment, any question? Now, having said that, but there's one thing I have to do before we go on, emphasizing territory. For example, in Article 1 of the 1933 Montevideo Convention on Rights and Duties of States. Gone too fast for you, Lolly? I'll keep up. Repeat it.
Article 1, 1933 of
Article 1 of the Montevideo Convention on the Rights and Duties of States said the state, as a person of international law, should possess the following qualifications. Going too fast.
Yeah, just a fast.
Anything for your sake, really. The state, as a person of international law, should possess the following qualifications. A permanent population. B, and it's B I'm more concerned about, a defined territory. Defined territory, yes. And if you have your highlights, I would like you to highlight territory, because we're speaking about territory. This is why I'm citing this provision from the 1933.
A defined territory.
A defined territory. Yeah. It's a permanent population. When people live permanently in the place. No way. But it doesn't speculate. It's a simple permanent population. But what is the difference now?
Migration might be. That
Well, it doesn't mean that, okay, good. Well, yeah, that's right. I mean, it doesn't mean that people cannot agree with it. But there will always be many people have left Trinidad and have gone to other places. But there are many of us, yes, who have stayed back behind.
Okay, so my thought was that, let's say in states where there's conflict and all of that, the fact that people will constantly move away from that place will not affect.
That might be a temporary thing, yes, but it will affect the state. And that's right. I mean, as we speak, there are a number of people leaving Syria in the conflict. But of course, you still have a number of Syrians still out there. And hopefully, after the conflict, they will return to Syria. So, but it's just still have a population. Countries that everyone is, they still have millions of people living. Yes. They define the territory. Government.
So that's a network, that's it.
See, that's right. So, and D, the capacity to enter into relations with other states. Every independent state will have these characteristics. We'll be more interested in the D, in the defined territory. So, for example, the Kurds, without territory, can't be a state. There are people, but they cannot be a state. The Palestinians are a people, but they don't have a Palestinian state. And I would think that they're probably another example. But these two examples cover it.
So, Mr. Francis, is this Article 1 to 33 of what?
Article. Okay, we're looking at the convention. The convention is the 1933 Montevideo Convention on the rights and duties of states. And what I've just cited is Article 1 of that convention.
Okay.
I think I'm going to be wrong.
Article 1.
Why would you write it? Sorry about that. The convention, so the convention first, and then we looked at Article 1.
Okay, thank you.
Now, how is title to territory acquired? In your reading, you will see that there are 5 different methods of acquiring title to territory. 1, I will cite them and then we'll look at each one in turn. Occupation. 2, prescription. 3, cession. C-E-S-S-I-O-N, cession. 4, accretion. A-C-C-R-E-T-I-O-N, accretion. A-C-R-E-T-I-O-N. Never heard of this word before. Accretion. What is that? Everything will become clear to you. And 5, conquest and annexation. Conquest. And I would like you to put a question mark alongside that. Conquest and annexation. To become clear to you a little later why I'm asking you to put this question mark. That's right. Looking for the highlighters, and you see, finally I'm seeing highlighters. You always like to use highlighters. In nighttime, we didn't get much use of highlighters. What is occupation? In other words, what it means is you can have situations where a state, let's say for example, we have a dispute between 2 states, and one of the states is basing its title on occupation. And occupation is not just simply, physically occupying the land. That's occupation. Not simply that. That may not be enough to confirm the title. The question was, what requirements should the state relying on occupation as a basis of title have to satisfy? What do you have to show? And 1, basing the title, claiming this land is mine, this island belongs to me. on the basis of occupation. One of the conditions. One, at the time that you made your claim, the land was terra nullius. It's Latin.
At the time,
The claim was made. The land was terra nullius. T-E, or res nullius if you like. T-E-R-R-A. In Latin, terra is Latin word in land. Nullius, meaning of no one. In other words, at the time I made my claim, this land belonged to no one else, no other state had title. Terra nullius. And two, that from the time that claim was made, there was effective possession. There was effective, so it belonged to no one in the first place. Then, of course, I reduced it, subjected it to my possession. Effective. It must be effective possession. There's a second element that you have to be present in order for a claim based on occupation to be valid. Now, we have to look. Terra nullius is probably not, well, it could be difficult. Could be difficult because, could be problematic. Because what is it? You say land belonging to no one. You say that at the time. But again, it should probably be more. When we consider occupation as a basis for title, very often we look at situations where the facts are not very clear. Land belonging to no one. But maybe 5 years after you were there, another country may have entered that territory, conducting certain types of activities. So sometimes, not all the time, but sometimes you can have two countries, maybe even three, being involved in activities and others at the same time. Very. And then some might have started and afterwards involved. Another new one might have come in and give that sometimes, especially the age of this country. And those of you who read some history, it's very obvious that we go back centuries, especially if you're looking at things like discovery. Who discovered that land? Some they say, well, the British were there first. Usually looking at European countries, age of expansion, age of imperialism, age of colonialism. Yes? So we don't have experience about new lands. We were told, well, Columbus came. We were told Columbus discovered. He discovered in the name of the Queen of Spain. That is the sort of history. So Spain would say, everything belonged to us. Discovered. It was terra nullius. Some of these islands were uninhabited. Nobody lived in them. Columbus came in the name of the Queen of Spain, Isabella. Queen Isabella. How about that? What do you think about that? Still, what do you think of Laurie Taylor? Yes, well, that's of course, they all do the same thing. They came. It's either they said probably one, and they came just 7 years. But sometimes it could have been by conquest. They would come. The Navy is there. Somebody could have been there before. Now, that would not give somebody else that's not tell movies. But you could conquer it. Take it over by force. Yes? And we here in the Caribbean history, anymore with basic knowledge of it, exactly that's what happened. Islands going from one European power to another. Through wars, final wars. One conquers the other, and at the end, territory changes hands. Changes hands. So you're no longer British, you now become French, you become Spanish, whatever it is. Yes, Bishop? Anyhow, terra nullius. So sometimes it is quite possible you can have more than one country involved. And that's when you have this problem. And who was there first? And so, supposing you're in one part of the territory, this territory has some size, so I may not even have been aware that you were there. You're in the east, and I came in the west. You're in the north, I came to the south. And I'm doing whatever I'm doing now in the south, you're in the north. You have this type of problems. But you probably may not even have been aware of my presence, neither am I aware of your presence. It's just quite possible. Yes,
That happened in the continental US. That the English was in the north and east. The French was in the Louisiana area. And Spain was in Florida.
That's right. And exactly, that's right. And if you're taking a continent, remember, you wouldn't bring the entire continent under your control all at once. So you have a certain area. The question is how much of that area? You make a claim, yes. But how much of it? How far does it extend? You have all these problems. And until you could, and this is why we need effective control too, because if you wouldn't bring it, you just say, you just probably put in a circle and something. I say, oh, this is mine. What are squatters? Not the domestic land, squatters, squatting community. You might come in there and say, look, you put down this. I'm coming after you. Yes, we know. You go up on the hills and so that's what happens. I'm going in there to squat. Probably might mark out a particular area as mine. Vishal is coming after me, so I'll say, if Vishal wants to live on there too, doesn't have anywhere to go. So he has to enter into a deal with me. It's a squatted together. He's taking now, send it to me now. So that I would there, obviously here is mine. I might decide, you're squatting. You're not going to keep me out. I'm going on there too.
How you could tell me I squatted when you squatted?
Well, let's see let's see So I'm going to decide, I'm not going to pay you anybody because I know you're squatting. So if you could get me, you try. Yes, Tanyaka. I might be stronger. I might have some confidence in my strength and to say that you can't get me out. So therefore I go and I start building up the line. So squatting, protecting. We'll come back to it. So this is the thing with the territory. Sometimes in fact, and if you read any of the school of something, as I said, very often it takes us sometimes centuries. Centuries. Guyana, Venezuela. That didn't begin yesterday. It went a long way back, centuries. And then, of course, the economics. And sometimes the facts are not always very clear. Facts to be misused. These are the requirements. And so tell me this. The more difficult one, of course, is in terms of what do you mean by effective possession? Because if you're basing a title on occupation, you must refer to an effective occupation. How would you define? How do you think effective possession should be defined? Yeah. What do you think the state should do in order to make its possession effective?
Would it have to relate back to the 4 points you made earlier? Permanent population, defined territory, government.
What do you tell me? What do you think?
For to be
What is that for a state? Because at that point, what we're looking at is not really a state because I'm taking it to the part of my territory.
Mhm.
Yeah.
But to exercise effective control, I should have these. What I'm looking for. I should have these factors, not factors.
So in other words, you think
These elements. These
okay,
elements.
good,
Yeah.
Okay. In other words, you're saying you should have a settlement.
I should have a settlement. I should have a government. I should be able to have defined
right.
borders.
Some sort of administration on the thing
Yeah.
to make sure that things go on. Yes. Okay. Yes. He's thinking of settlement. That's very reasonable. That's very reasonable. Put people there, and that's what in a number of cases would happen. You would settle a place. You would settle it. Yes. Or islands. Bringing people. Yeah.
The United Kingdom, they were trying to do that just recently, targeting the islands.
Farmers.
question. Probably some months ago last question.
She was settled to establish a
Some
settlement there.
persons on the island to live, to establish some sort of a settlement.
I'm not aware of it. I'm not aware of it. Well, okay, so they have the island, they claim the island, and then they put people to live on the island. So in other words, they're establishing a settlement. And if you establish a settlement, if you have people, then you have to have some form of administration. Wouldn't you? Yes. Well, and that's a reasonable and in many cases. But you can have a situation, Michelle, where maybe it may not be possible to settle. The island could be, that's right, maybe uninhabited and inhospitable. Conditions there are extremely difficult. Windswept island, yeah? Difficult for people to live on it. So in that case, it becomes a little difficult. Island, why want to survive? The nearest landmass, this closest would be hundreds of miles away. You're gonna want to live. Yeah. So in that case, but you want to bring the island under your control, but you want to say it's effective. So would you insist in these circumstances, remote, inaccessible, yeah, inhospitable, the climatic conditions of the island? Would you still insist on settling it?
Well, no.
To make your possession effective? You say, oh no. So what would you have to do? To make what would constitute effectiveness in that case?
Historically, I would militarily seize the island and protect it, and it would fall under the banner of my protection.
So you'll just make sure that you could not accept surveillance, make sure nobody else is there.
Basically.
Yeah. On that point.
Historically, though.
Yes, yeah.
Not now.
We'll take a break. When are you looking at me now? You're not here 10 minutes yet. No, we'll take a 10-minute break and we'll take a 10-minute break and then we'll come back. 10 minutes, sir.
Okay.
I took more than 10 minutes.
Yes, you did.
We won't hold against you, don't worry.
Except we always yes. Occupation. So terra nullius. And then, but it's a question of fact again. Was there some country before? But the problem is that you have to appreciate that sometimes the facts are not always very clearly established when you deal with things like occupation, especially if the territory in dispute is one that probably may be remote and very inaccessible. It wouldn't be so unfair, but sometimes if that is the case, it makes it more difficult to ascertain the facts as to whether you see those you might one country that is we were there before, maybe not even realizing that another one could have been there. When we got to the island, we saw no sign of anyone. So this is the thing. So terror is fast sometimes. Maybe not really settled. Effective occupation. Vishal said something very sensitive. He said, well, claiming it. Bring some people to live there. Set up an administration. Then there won't be any doubt with respect to your presence there. Establish a presence. This is basically what he said. Show your presence. Show that you have brought it under your sovereignty, under your control. This is Vishal saying, effective. And indeed, if you do that, there won't be any problem. Everything will be much clearer, much simpler. But as we said, what if probably doing that may not be very feasible, may not be very practical? What if you are considering maybe an island, it's small, and it is remote? And in some of the cases that you'll be looking at, this is exactly what it is. Maybe it wasn't even worth setting up any settlement. Now, the case, and that is the best way of looking at these things, through the cases. And the first case is the Clipperton CLIPPERTA, Clipperton Island case. And this is a dispute between France on the one hand and Mexico. Clipperton Island case. Clipperton Island. This dispute came before arbitration.
Clipperton Island dispute?
Case.
Case. Okay, case. Let's see. Yeah. What is it? It's a dispute. It's involved a dispute between France on the one hand and Mexico. This Clipperton Island is an island in the Pacific, some miles away from Veracruz. It's Mexico. A French naval officer, sometime in the 19th century, claimed it. It was a history. Claimed it in the name of France. Island, Vichy Island. He saw it was uninhabited. Nobody lived there. Michelle claimed it on behalf of France. Pay careful attention to what followed. France later annexed it to its territory, passed a law, enacted legislation, having it incorporated into their territory. Yes? After that, let us look at what happened after. This legislation incorporated the items of the French territory. Later, there was one act of surveillance. They sent the naval vessel to go around to make sure that everything is okay. Nobody else is there. Two, they issued a license to a company to extract water. You notice what?
Pardon? Guano, but poop.
Yes, yes, the droppings of birds. For man, you yeah?
But it's a poop.
Yeah,
Right.
guano, Guano.
One.
Yeah, before it used to be a very important manure and so on. Yes.
Fertilizer.
Yes.
Oh,
Yeah. One. That's right. Well, I suppose not as important. No, it used to be then, but of course, the company extracted fertilizer. Yes, that's right. Droppings of birds in that particular area. One. Or as Michelle put it, bird poop.
I was trying to use a polite word.
Yeah.
Bird or bat?
I said bat, but I guess
It could be other words.
Yeah.
That's bad. Yes. Anyhow, Mexico later on, that's the problem, what happened, decided afterwards to make its own treaty. Not France was there first. But remember, in the context of effective occupation, possession, what France did, she did not establish any settlement on the island. Remember that. Okay, Michelle? So therefore, was it effective? That's because we cited what she did. She simply, there was an act of surveillance and the naval vessel around sometime later, and then issued a license to a company to extract one from the island. Was that enough? By way of effective possession. Because we say this is a requirement if you're basing a title on. Did France do enough? What do you think?
that's a difficult question.
You think France did enough?
So
You
the
think
question,
Huh?
so your question is, if they didn't establish a settlement in the island, is that good enough for them
That's
to say
right.
that
That's
that's
right.
it?
Would you insist?
Uh-huh.
Remember, Vishal had told us
Mhm.
that you would have the expects for the thing to be effective.
Mhm.
Settlement.
Some physical sign of presence. This is Vishal's argument. No, that's right. You've had the benefit of a learned man. This is how he sees it. What do you do, as he said? So, using the visual test, it means that France would not have done enough
exactly.
Exactly.
because, of course, it's not effective. Michelle is expecting settlement and administration. But remember, the island, as we said, was remote. It's a small, uninhabited. Even in terms of economic sense, all you had there was one. Now, arbitration held, and the acts that I just outlined, i.e., it enacted the legislation incorporating this island into its territory, in a sense which really consists a manifestation of its sovereignty, claiming this is ours. We have the law to defend. And I want you to pay some attention. Although the naval officer had claimed it in the name of France, France didn't just look at it there. That is an individual making a claim. There should be something further, something additional on the part of the state to do something to say, yes, we are going to claim it, display it, show some sort of sovereignty, display some sort of sovereignty. Maybe just the officer claiming it on behalf of the naval has been enough. You, the state, must do something. Because the officer could say he's claiming it in the name of France, and France may not be interested. France actually was interested. She passed the legislation, passed the law. Okay. That's one of the things she did, by way of exhibiting sovereignty. 2, there was an act of surveillance sometime later. And 3, the license, issuing of the license for the exploitation of guano. Was it enough? The court said yes. Because they said that it's not in every case that you necessarily would have to establish a settlement. What is effectiveness in that, in a sense, like, is something that is relative. You have to relate it to the circumstances existing in the particular area. And given the fact that the island was uninhabited, if it's an inhabited island, they probably would expect to establish some sort of administration on the island. But it was uninhabited. So you're going to administer the wild birds there and the guano. You had people settling, the probably would be an administration. But they said this was not the case. Yes? And then of course, an island, very remote, are able to send up people to live there. How are they going to get their supplies and so how are they going to survive? How would they live? Because the island probably was so small, so remote and so on. And probably in terms of human habitation, especially at that time, back in the 19th century, it could have been very, very challenging to establish any settlement in the island. Yes, Ms. Kira? So the court said, what those acts that I just outlined would have been enough on the part of France to show that its occupation was effective, given all the relevant circumstances, i.e., the island is remote, it is uninhabited. So therefore, you're not requiring France to do very much by way of effective occupation. They say this is something that is relative. How much you do, you have to relate to the circumstances. And given the circumstances, which I have just outlined, it meant that you can satisfy that France did not to satisfy that its possession was effective. Yeah. Another case, the Eastern Greenland case. Eastern Greenland. It's a dispute between Denmark and Norway over Eastern Greenland. Over Eastern Greenland. Now, Denmark had settlements on the western side of Greenland, western side, but not on the eastern side. And Denmark, I think, was in a sense, well, some countries have considered that Denmark exercised sovereignty over all of Greenland, the west as well as east. But Norway contested that. No, saying that it is only over western Greenland, where she had the settlements, where Denmark had the settlements, that were effectively in effective possession of Denmark, not the east. Because in the east, she didn't have anybody living there. She did not establish settlements. Again, applying the visual test, she did not have the settlements. But the court, PCIG, permanent code of international justice. In terms of determining effectiveness, again, you have to relate it to the existing conditions in Eastern Britain. Very, very, very cold. The impossible native. Probably the first to death. Remember that? Still. After conditions. The hospital, you could have a great thing that would probably survive, especially in the back of the days. Very difficult conditions existing. And Denmark would have been expected to do very much in order to establish that its possession was effective. What it did was enough. In other words, then, maybe just on the part of the smallness. But regarding settlement and so on, no, not expected. Because in relating what it did to the existing conditions, and they were extremely difficult. These are the Arctic conditions and the impossibility of the entire environment in Eastern Europe. So again, Denmark was successful. Norway wasn't, because Denmark was not expected. Just as in the Clipperton Island case, very little to show by way of effective occupation. So the effectiveness of the possession growing is to be related to the conditions, the prevailing conditions in the conditions prevailing in the particular country. Say, it's democracy, is it? You say, okay, no settlement. But no settlement, is it? Are there people living there? And if you don't have people living there, what do you need to set up an administration? To administer what? Yes? Because if you set up an administration is what people. And because you don't have anybody living there, not any sort of activities going on there, then you say, well, the country probably maybe claim it as part of its, in terms of its laws, it's part of this country, its laws will also be applied to it. But in terms of settlement, you want to rely, insisting on, just as in the Clipperton Island. So these are two cases where the authority will help us to understand what really constitutes effective possession. Sometimes more or less depending on the circumstances. Reading. Are you looking at me? Are you reading my lips? Yes?
Okay.
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 Okay, yes. Yes. It's a relative thing. Don't see it in absolute terms. Try to understand it in relative terms. You are relating the effectiveness to the conditions existing. So if in terms of the conditions, it's difficult, remote, uninhabited, blah, 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 you expect violence. It is relative, not absolute terms. You must have it hard and fast. Well, you didn't set up any administration. You didn't set any people to inhabit the territory. So therefore, you cannot be considered to have been effective possession. That's two cases. Whether you have the authority. In law, you must have authority. So familiarize yourself. I mean, okay, I'll just give it to you with these two cases. One, the listening.
Yes, familiarize myself.
With these two cases, the Eastern Greenland case and the Clipperton Island case, so that you can understand, you can have a better appreciation. Don't just take my word for it, but one listen. Like Bishop, read up on the case. That's his reading. That's his reading. And look to see exactly what as you go through the cases. Quiet, the peace and quiet of your study. You read this case, and you have your highlighter. And you look at to see what the court is saying regarding this issue of effective operation. And I think what I'm trying to get across to you is the fact is it is something that is really don't see absolute. And secondly, to sometimes the question of the facts and so on. Okay. This is occupation. Prescription. Some countries, some states, France, restrict one of the parties is relying on prescription. Now, what will it have to show if it is basing its title on prescription? What sort of facts must it establish to illustrate, to demonstrate, to indicate that it has a good title on the basis of prescription? Prescription. You've heard the term sometimes, you have a prescriptive right to something.
Actually,
What comes into your mind? Yes. Prescription, prescriptive right.
Goes hand in hand by
Squatters' rights. Yes, sometimes, Michelle, you may have your property, yeah, and you allow someone to live in the property for a long time. You're not collecting any rent, Michelle. You're not showing that it's really under your control now. You're allowing
Tanya.
Miss Tanyaka. Not Miss Tanyaka. Tanyaka. You're allowing Tanyaka to live rent-free in the property. Guess what? Later on, Tanyaka comes and says, "This is not my property. I have it by prescription because you have not been charged." So even if you like Tanyaka and you have enough money, you don't want to charge her, at least you should charge her what you call a rent. You ever heard the term peppercorn rent? Yeah? Yeah, but that's what it is. It's nothing much. $1 a year, something that's nominal. But just to show that you are in charge, you are in control of the property, and you don't want it to go last. Okay, Laura?
Yes.
Charge the peppercorn rent. You don't really have the money in the means. But it was good charge this peppercorn rent. So too, if you have property, territory, you have to be vigilant. Because the fact that you have title to deal, and you're probably not very vigilant, you're not alert, you probably are allowing others to come in and conducting activities on the territory. Down the road, this will work against you. Because although you might have had, yeah,
How much time has to pass?
I was gonna
Okay,
say
good.
how much time has to pass.
No, I like that question.
I was thinking about it as well. How much time needs to pass?
Wise men. As you wish. When we're dealing with when we're dealing with customary international law, you see, this is the thing. It simply says long. Okay, let me tell you what it has to show. Long, peaceful, continuous possession. That is basically on prescription. The requirements that you have to satisfy. Possession was long, it was peaceful, it was continuous. The question is, of course, and that's a very good question. How long? I don't know. Well, no, as in most cases with customary international law, these things cannot be determined with mathematical precision. So you see law. But what one has to do sometimes is to look at the cases sometimes to have an idea as to what they consider law. For example, even in some disputes submitted to arbitration of the court, the parties sometimes will agree. Let us agree on a period of time that for the purpose of prescription we can say constitutes long possession. For example, in the Venezuela, Britain dispute over Guyana, they were submitting in the dispute to arbitration. It took 50 years. But that was with that particular case. But one cannot generalize and say it is 50 years. So it shows that the parties in that case, for purpose of the length of time, let us accept 50 years. And they settled on the 50. But you're quite right, as I say, you cannot say it is so many years. It just says long. So we have a little bit. Peaceful. What do you mean by peaceful? Simply meaning that there was no war. In other words, then we might have been there, but there been terror and at first. You come in. Later on, another country probably is coming in, conducting some sort of activities, probably trying to demonstrate, show that it is trying to exercise some degree of sovereignty over that territory, what do you do? What do you do?
Someone is falsely trying to
Huh?
exercise jurisdiction over a land where I
Yeah.
am living.
Yeah,
I
what
fight
do you
back.
do? Yeah, what do you do?
Fight back.
Hmm?
I fight back. Yeah.
You want to fight first. Okay?
Well, I
Okay.
mean, if you look at the territorial dispute between Israel and Palestine, that's what's basically happening.
But remember, now especially,
Mhm.
you're not supposed, but we have outlawed the use of force.
Oh, we have, okay.
But you probably might be right. I mean, you might look at it as self-defense. You're defending your territory.
Mhm.
So in that context, you probably may say, well, yes, you can use reasonable force to expel any unauthorized settlement or whatever it is on your territory. I suppose you can say that because it's a sort of a self-defense. Yeah, you're defending the territory. So in the context of self-defense, yes, you do it. But you may not necessarily want to go escalate it to that point. But certainly, you will have to protest. Whatever you see, rights that you have to protect it, and somebody is infringing it, you don't just sit and look and see nothing. You will have to take some form of protest. And not just from going through the motion, showing clearly that you're serious. You're treating the matter as a serious matter. So you may say, look, if you continue with this, maybe pay my case. Ministry for the Heritage, Trust is going to be concerned over this matter, treating it as a very great matter. And should it continue, we will be considering maybe submitting this matter to the court or to arbitration. So sometimes, every time I get the letter could appear to be a bit stern. And finally, right, you might see, when you take all reasonable means to defend our territory. I'm not saying military means, I say all reasonable means. But you believe probably leaving no doubt that you're even prepared to use some force to put an end to that situation. Or you may decide we'll take it to the Security Council. Yeah? So it's a problem that we have. And infringing your territorial, you could have your territorial integrity. So you wouldn't. But the fact is, there must be protest. And if you protest, then it's not peaceful. Even if you didn't use military force, or you could protest. So, for example, Venezuela is claiming this huge, large tract of Guyana's territory. It's claiming it. Guyana invited a vessel to come in to conduct surveys, seismic surveys, exploration to see whether or not there are resources in the sea, territorial waters. Venezuela, looking at the vessel, she's claiming it as a territory. She did not grant permission to the vessel to Guyana because Guyana is territory. Venezuela decided to send a naval vessel to seize the ship out of what Venezuela considers to be Venezuela's water. Now, seeing that she has that claim, she, of course, is asserting herself. All right, but she considers to be all right. Because if she just stays and does nothing, many years down the road, I said, well, we saw this thing, it was good, it was being done openly, and he did nothing. So she publicly showed that that would not happen. We are not going to be faced with a representative in faith and concrete that are prepared to take certain action. And that's another matter. That is for all of Venezuela's stand. And indicating clearly that we are willing to use military force. Should we come to that? Yes, Michelle?
Mm-hmm.
Okay, good. Of course, they could have gone to the diplomatic channel, even if by way of registering a protest. Protest can take different form. Could have gone to could have probably said, as I said, this is a matter we will undertake to the Security Council. She did something that is far more assertive, far more forceful. The concern, Warner?
So, she has guidance have a basis for claiming the land on the basis of prescription. Since they
I wonder why I introduced that in this stage. Clearly, there will be interest showing it, yes. But one thing to remember for the time being, Guyana's title is based on British land. We have to consider from the Guyanese point of view what was the situation at the time of Guyana's independence, because they are the successor state. If Britain didn't have title, then Guyana can't have title. It's just like here in Trinidad and Tobago. So this is what I'm new states coming to be. We are successor state. We are successor state to Britain. So let's say Britain didn't have title to Trinidad and Tobago. And let us say, okay, that's what happened. And Venezuela was saying that Trinidad is part of Venezuela. Then, of course, if it turns out, yes, Britain didn't have title, then indeed Venezuela will title stuck at the time of independence, 31st of August 1962. This is when we look at it. So we look at the situation and say, yes, 31st of August 1962, Britain had control over things. British Trinidad and Tobago was a British colony. As of the 31st of August 1962, Trinidad and Tobago became independent. So whatever rights, whatever thing regarding Trinidad and Tobago devolved on Trinidad and Tobago, no longer Britain. So all this where we're standing on now. So it's Trinidad and Tobago territory. Before, in the colonial period, it was part of British territory. So we were British subjects. Independent now. So the title passed from Britain to us. If Britain did not have the title as of the 31st of August 1962, we would not have had a whole claim. Luckily, nobody was claiming our territory. Unlike, say, the sad situation regarding Guyana, where another country is claiming the territory. Of course, later on, we're going to validity the legitimacy of the claim and so on. But for the time being, just say that there is things. So prescription, long, peaceful, continuous case. Just get an appreciation. Knowing just get an appreciation. You see, when they must have authority. You don't just say long, peaceful thing. As stated in such and such case. Yeah? You're right in saying that, but you should have authority. And don't just say, glory says to the clouds. That was in such and such a case. Yes, that is our authority. That is how you approach legal problems. What's our authority? What is the authority? So the authority, I said long, peaceful, continuous possession. What authority? I go to the island of Palmas case. Island of Palmas case. P-A-L-M-A-S. Island of Palmas. It's done by the Philippines, Southeast Asia, the Pacific. Island of Pacific. Okay, first, island of Palmas is tiny, very, very small. It's a few miles long and a few miles wide. Very, very small. Island of Palmas. What is the problem? It's a dispute involving, on the one hand, the United States and the Netherlands. What happened was this. Under the Treaty of Paris of 1898, Treaty of Paris of 1898, Spain ceded the Philippines to the United States. And the United States thought that the island of Palmas was part of the Philippines when the Act of Cession took place in 1890. This is what the United States thought. Now, Spain is the one doing the cession, the transfer of territory. We'll come to cession later. That's a good example of cession. Spain ceding the territory, the Philippines, to the United States. Now remember, but the Dutch, even while Spain was involved in the region, was exercising some control over the island of Palmas. So in a sense, if you like, Spain didn't really have title over Palmas to transfer to the United States. Again, the United States is a successor to Spain. If Spain did not have title, Spain could not have passed title regarding this island of Palmas. Because in law, we said, no one gives what it does not have. Nemo dat quod non habet. No one gives what it does not have. This island belongs to Samantha. The only person can legally pass title is Samantha. If Candy takes it and purports to sell it to me, unless I'm yes, I'm buying it, I'm paying probably market value. Because I don't know, and I don't have any reason to believe that it's true. So I'm going to pay the market value. As it comes openly, you understand that? I have another one, I have a new one, right. But in a case like that, I will be the purchaser. I'm paying what the market value. Purchaser for value. I'm an honest man, Samantha. I don't know that the thing was stolen. Now, in that case, Lloyd, the title could pass to me because I'm the purchaser for value without notice. So I put a legal title invested in Samantha. In law, there's something called equity. Equity. Purchaser for value without notice. But you're not agreeing that completely. I have notice. Look at the facts, look at all the surrounding circumstances. So what did she come? Put it away and say, as opposed to dealing with your community. Something was hot. Probably I should have been put, just the way she's approaching it, I probably should have been put on notice. That's kind of the but she said, come on. She's brazen. But anyway, come back to the point. If you don't have good title, you can refuse. The same thing international law. National law. Growing up, the first thing you do if you're buying a property, you have to do a title search. Yeah. If the vendor does not have, there is some defect in the title, take it all into effect. So then it's usually captured. Yes, you can't say, well, I didn't know this. And that's a good point too. You see, in municipal law, because we have system, we have an administration, and the center. It is easy to determine this thing. I can easily know that this belongs to this property. You see, I'm buying it from, I'm buying from, I can go to the registry. But that's the first thing the lawyer does. He does the search and show that the title is good. The title is not good. Tell me, no, don't go there. Say it because there is some questions over this. Do you have a mortgage on the property? You have to determine all those things. Yes, the property is mortgaged. Okay, in that particular case, we have to make sure the client is satisfied with mortgagee. They want all these things to the project. It's easy in municipal law. But of course, under international law, it's not that as easy to establish title. And sometimes, as I said, facts could be somewhat uncertain. Simply because, of course, of the difference between the international system and the national system. The system, nationally, like a good, strong central system. They can go on, so many things will be easily determined. You get it point? Whereas on the international law, you don't have anything approximating to that. Whose territory was it? There is no registry that you can go to determine. So then one has to go down. Facts, this thing is going all the way, this is taking us all the way. You just have to come to try to do the research, historical research, to see exactly what will happen. Who was there first, how long did that happen. And sometimes the facts are not very clear. What you may see sometimes is that the two parties to the dispute could have been around the same time doing different things, conducting different activities with respect to that same area of land. You get the point? So this is why we say it's something that is relative. Who you think has better title, has a better claim, rather than saying absolutely this as against that. There's something that is relative. Peaceful, continuous. Continuous means you could have been there before me. But maybe for whatever reason you think it was worth your while, you lost interest in it, it means nothing to you at all, blah, 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 blah. And then someone else comes later and decides conducting activities, doing various things regarding this item. It's quite possible that your previous item could be lost, even though you were there before I was. That's again, because the other party is coming in and has taken to it. So, prescription, and so when I came, I can go back to maybe 80 years, 90 years, and see what I would do. But it was not continuous. So there are all these considerations. Then you'll come back to the island in Parliament about the island in Parliament. So what happened is this. The United States thought that this island belonged to the Philippines group. And then it was ceded to them in 1898. On one occasion, when the island was visited by a U.S. naval officer, he saw the Dutch flag flying on the island of Palmas. Well, the Dutch flag would fly on the island of Palmas. Palmas belongs to us. It's a ceded to us under the Treaty of Paris. Luckily, the two countries decided to submit to the dispute because Netherlands is saying, well, this is our island. The US, for its part, is saying, no, this is our island. Let's say, oh, okay. Submit the dispute to arbitration. Because the claims are conflicting. Whose island is it? Well, the Dutch is basing its claim on prescription. Long peaceful. Say before the Spanish had the Philippines, this island of Palmas, we were there, exercising control, in effective possession. And on the facts of the case, they were able to establish, that yes, they were there even before the Dutch. So, in a sense, if you like, it's pioneers, yeah, they're the Philippines. But Palmas was always in a sense separate from the Philippines, even though the United States said it was. And remember, the year of the session was 1898. So the arbitration tribunal had to look at the situation as it was in 1898. The matter came before arbitration in the 1920s, I think. But that is not the time that is not the date that is most relevant. The date when the session took place, 1898, when title, according to the United States, passed from Spain to the US. So if you like, that's what we call it critical dates. Sometimes you have to look at that too. What is the relevant date? What is the relevant time that we'll be looking at to determine this issue of title? In that particular case, it was 1898. And on the facts of the case, the court found, yes, the Netherlands were there. Now, US was saying, well, what was US claim? US was arguing before the tribunal They were arguing discovery. And they say Spain discovered all these places. Discovery. And they also argue contiguity. Sure, this is island that was just a part of the Philippine archipelago. That's what Spain was having. One, on the issue of discovery, the court said, wait a minute. Yes, there is discovery, but discovery per se does not confer title under international law. Discovery must be followed by something. So if you want to say, if you rely on discovery, at best what it will give you is an inchoate title, an imperfect title. But there is something additional, something that you have to do later to make good that discovery. You get a point? So discovery is not enough. And they found that the facts of the case here, well, after the discovery, regarding the island of Palmas, there wasn't anything else that's been. And on the issue of contiguity means one is close. It's contiguous. They say, well, again, if you're looking at that, and contiguity again is not enough to see because it is closest to my territory, that is part of my territory. You have to show, okay, it was really an integral part of this. So I suppose, let's say, for example, you had Trinidad, and I suppose you might look at Chacachacali and Williams and Molos and so on. Well, these islands could be considered integral part of the island of Trinidad. So therefore, whoever owns Trinidad owns those islands. But in other cases, when you say if you own Trinidad, it means that you also own Grenada. Further out. And if you own Grenada, it means that you also own St. Vincent. But that contiguous in that sense. It's the same thing with Capitan Island, with Mexico claim, argued on the basis of contiguity. Was it considered to be an integral part of Mexico? So, the court held long, peaceful, continuous. Well, the judge were there. The facts of the case, the judge were able to establish they were there even when Spain had control, sovereignty over the Philippines. They were present. The presence was established in island of Palmas, on the island of Palmas, and for a long period of time, long, peaceful possession. Again, on the question of the discovery, the court made the important observation that when you're considering a dispute, you have to look at the law existing at the time that the claim was made, in order to determine if the claim was valid, because its validity would be determined by the laws existing at the time that the claim was made. This is what you would see the literature refer to as the intertemporal law. So you say, for example, I made my claim, say, in the 17th century, say, I'm somewhere around 1650. You have to look at the time as I made my claim, based on law, to see clearly that, say, yes, it had to be in accordance with the 17th century, and not any other time. The intertemporal law. Yes. Any question on that? So again, they said, if and this is the point with prescription, it could have been there before another country. Yes, it may very well be possible that Spain was in the area before, but the fact that Spain, so the Netherlands was able to establish that it had it was exercising some rights over this island for a long period of time, peaceful and continued, then that is enough to have replaced even an earlier title that Spain might have had. You have to examine the facts very carefully. Go in. Listening? Yeah. Okay, good. Session. We're going to finish this thing. It's all of you can minutes. Give me a few minutes. Only Michelle and Samantha here. And I was ready to begin. Is that yoga? Ms. Philip? I'm keeping your attention. Yeah, session. A session is simple. I've just given you an example of session. Spain had sovereignty over the Philippines. Then in 1898, under the treaty, which often would take place through a treaty. We had the Treaty of Paris, Peace of Paris, ceded to the United States. Session. So, title passed from Spain over the Philippines, from Spain to the United States. As I said, usually through a treaty. So you go to the Treaty of Paris, Peace of Paris, and you will see clearly what the Spain ceded territory to the United States. Straightforward. This one is easy because you can just go and look at the treaty. Just as you can look at a deal. Treaty of cession, you can look at a deal. You have title to this territory, right now here is my deal. Here is my deal. So you don't have any worry here because you don't have an idea. Right. Say two, it's true. Which is much more straightforward than occupation and prescription, just session. So the United States could hold up the treaty. Although sometimes, as we said, sometimes you still have to go back to the prescription and these other things too, because the other state contending title probably could have had a better title than the person transferring it to. As we saw, the Netherlands had a better title than the Spaniard. So sometimes you know, maybe you might have the session. If it's just session, then of course it's straightforward. Another example of session, I think somewhere in the 19th century, the mid-19th century thereabouts, Russia ceded Alaska to the United States. As you know, Alaska is now one of the states of the United States. It wasn't always so, in the 19th century. Formerly it was Russia. That's why Palin could have stayed in Alaska. It's Russia. Russia was once part of Russia. Sorry, Alaska was once part of Russia. It no longer is part of the United States. Yes, sir.
But didn't actually the US purchase Alaska?
Sold it.
Yeah, through cession.
Okay.
They call it cession. That's right, it was Russia. But yes, they won't give it to you free. You won't give me your house free, will you? Yeah? Yes, they purchased it. Yes, in those days, nowadays I suppose it's less likely. But certainly in those days, look at US Virgin Islands. Previously, until 1970, it was Denmark. It was Danish, Danish colonies. And in 1970, Denmark ceded the Virgin Islands to the United States. So they were no longer Danish. They then became USVI, St. Thomas and St. Croix and all these places, through cession. Again, I just said probably maybe. So these are good examples of cession. But usually cession is the problem. It's not USVI, because Denmark no longer exercises sovereignty over those islands. So this is an issue regarding cession. Could be done that way. Or, I should come another way too. Here in the Caribbean, those of you who read West Indian history will be all too familiar with the situation where you had a lot of wars fought by European powers over our islands. Sometimes at the end of the war, you will have a treaty. And sometimes as part of the terms of settlement, yes, as part of the terms of settlement, the territory sometimes will move from one, technically the territory will move from one European power to another. And that's the story of West Indian Islands. Moving, it was now British, then French, then this, moving from one to the next. Usually at the end. So although you had a war, but there will be to settle. You have a treaty. And part of the settlement would have been maybe, okay, this island will move now from you, Spain, to Britain, and it will continue going. So they never said, not never, but hardly did they say contrast. So even if it comes at the end of the war, the treaty is coming, the Treaty of Cession is coming at the end of the war, we still will have to say cession rather than conquest, because they concluded this treaty. You might say, what's the difference? Well, yes, even that much different. Because my back was against the war, and the conquered power, and you more or less now, in terms of the agreement, you have a dominant position. And we have to agree to the terms. But it is still a session, officially, in a formal sense. Any question there, Tanyaka? Okay. Accretion, going quickly. Accretion. But none of you knows what is accretion. And the only one in this room knows what is accretion. Okay. This involves the assimilation of new land formation into old land formation. What an odd is that? Not very clear. Come on. What am I saying? How can you have new land?
Is that like annexation? To annex something would be.
No. We haven't reached there yet.
Oh.
We're still in accretion.
Okay.
Accretion. Yes,
So
Tanya?
like when that island came up after the earthquake near Pakistan, I think.
Absolutely right. I thought I was the only person. Okay. take a bow. Yes. New land. Yes. Through some natural phenomenon. It's not an artificial island. Could be a volcanic eruption, or as Tanyaka just very correctly said, earthquake, any natural phenomenon. Or sometimes islands form at the mouths of rivers. The silt, and some coming down from the river, large rivers. We're not talking about the Caribbean River. We're talking about large rivers coming over all these silt and sometimes you have islands forming at the mouths of rivers. New land. Of course, that new land at the mouth of the river will be part of the territory of the state, which is good. Yes, continuous. Yes, good. New land, so you call it accretion. Or as Tanyaka said, the island is formed in the territorial sea, Tanyaka, your territorial sea, then that island will be part of your territory. Assimilation of the. Or sometimes look at the situation with rivers. Again, we're not looking at the Caribbean, we're looking at large rivers. As you know, the river might be the boundary between two states. But you know, rivers don't always go in a straight line. The river might change its course. Changes its course. Now that could be the detriment of one of the states and to the advantage of the other. Over time, even if you're not seeing it on a daily basis, over time, maybe about 50 years, it's wait a minute. This river was going this, now it's all over the here. But we were hardly noticing it. It's only after some years had passed that we have observed that. Well, what will be the position? Because that will be to the advantage of one state. If it moves closer to this one, it means there is more land over here. So what do? Do we take the river where it is now? Or do we say, no, it should not make any difference? Yes, Tanya?
Would it depend on the wording of the treaty or agreement between the two states?
Depends on me.
The wording of the treaty or agreement between the two states.
Well, all right.
You said
Good
that
question.
just directly that it's the river is the boundary.
All right. The two states probably could agree and say, look, we're not going to change according to the change of the river. We're going to leave the boundary where it was before. You're absolutely correct. That's right. If the two states agree that is how we will settle the matter, yes. Nobody could interfere with that. Nobody can challenge it. Yes, you're absolutely right. But supposing you didn't have the agreement. If you have the agreement, fine. It's good to have agreement. But if you have the agreement, fine. If you didn't have it, okay. What the law says, customary international law says is this. If that change in the course of the river was gradual, almost imperceptible, then you would take the boundary, the new course of the river. So somebody will suffer the loss of some territory. So be it. Tanyaka, so be it. So the people in the river may very well find themselves on the wrong side of the wrong side. But it has to be slow and gradual, almost imperceptible. So if it is very sudden, you had a hurricane, and the river suddenly moves its course, then of course the boundary will be the old riverbed, not the new one. And I suppose the rationale for that is, if it is slow, you probably have time to adjust to the new situation. If it's very sudden, I suppose there wouldn't be much time for any adjustment or anything. So you're saying, well, leave the old boundaries. As Vishal is making sense here? This is this. And that rapid change in the course, we call it avulsion. So accretion, slow, almost imperceptible. The other one, of course, avulsion, suddenly. There's a hurricane, there's a flood, and almost overnight, the boundary has changed, the river has changed its course. So we're not going to, for the purpose of the law, we're not going to take any notice, any cognizance of that change. And it's straightforward. And we come to the next one, which is interesting. Conquest and annexation. Again, Maury, we are in West Indies. We're in the Caribbean, West Indies. Yes?
Wasn't Cuba annexed by the US?
Cuba, annexed.
Yeah, by after the Spanish American War.
But it wasn't that under the same treaty that Spain had Cuba before? And the 1898 treaty, wasn't there something there with Cuba? Something there, like history is missing. I can't quite remember. No, the 1898 treaty. I think Cuba somehow came into this thing. It's a fairly comprehensive treaty involving a number of territories. I'm not 100% sure. Was Cuba ceded to the United States in the 1898 treaty? I'm not too sure.
I can't remember exactly.
I can't quite remember either. Conquest and annexation, West Indies. This is West Indian history. Conquest. Is that our islands, because we were colonies in those days, but the European powers, the British, the French, the Spanish, the Dutch, these are the main ones, involved in these things. There was a lot of wars fought by European countries right here. So we are the cockpit of European rivalry. Over that sometimes, one conquers the other. Sometimes that's part of the conquest. A country that is conquered already loses territory. For example, after World War I, Turkey, Ottoman Empire, lost its empire. All the countries in the Middle East were part of the Ottoman Empire. So, everybody actually took a form of special kind of arrangement called a mandate regarding these territories. In some European countries, they administered, but it was no longer all the Middle East that was part of the Ottoman Empire ceased to be part of the Ottoman Empire because they were conquered. As they say, war to the vanquished. There was a price, there was a penalty. Taliaka to be paid when you lose one. Suffer losses. When Germany lost the First World War, she had heavy reparations to pay. Many historians say that was the beginning of the Second World War because of the kind of arrangement. Yeah?
They lost the Rhineland, right?
Yes, they lost a lot of things. They lose territory. Sometimes you have to pay a way of reparation. So too, this is why sometimes our islands pass from one to the other. But as I said, in many cases, at the end of those wars, you would have a treaty. And the actual transfer of territory, title to territory, would be the treaty. But, okay, let's say you didn't have a treaty. If, say, one conquers the other and decided to take this particular island and have it incorporated, without any treaty at all, have it incorporated into our own territory. Well, of course, that would be by way of conquest. So you had the physical fact of conquest. But conquest alone is not enough. There must be the intention on the part of the victor to have the conquered territory assimilated or incorporated into its own territory. If it doesn't do that, it just conquers, then of course maybe title doesn't last, then a change of title. So conquest followed by the intention to have the territory incorporated. That is called annexation. In other words, the victor state, victorious state, has annexed a conquered territory to its own. Annexation. Any comments on that? No. As you know, international law is not static. And certainly regarding the issue to do with the use of force, war, we know that now can be a war is outlawed. So don't ask me how we can be fighting in Syria and how this war is going. But under international law, war is outlawed. First, we started, as you remember, with the Keylog-Briand Pact of 1928. Remember that? Countries, parties to the treaty, agreed to renounce war as an instrument of policy. Remember that? Keylog-Briand Pact. And then later, we have Article 2, Paragraph 4 of the Charter prohibiting the use of force. Because it starts something like that. States shall refrain from the threat or use of force. That's a charter. The only exception that you have to this rule is Article 51 that deals with the right of self-defense. Under Article 51, you can use force, yes, to defend yourself and your territory. You can get, or the Security Council itself can still use force to put an end to a threat to the peace, a breach of the peace, or an act of aggression as defined as provided under Article 39 of the Charter. These are the exceptions. So we can safely say today we can't rely on annexation because of this use of force. However, if that annexation had taken place, say in the 18th century, some of them, you can't rely on today's law and say, well, we have to do time, because the law at that time did not, and that's what we meant intertemporal law. The law at that time, right? I'm relying on conquest because the laws as it existed then did not prohibit the use of force. We all use force, and so therefore the title would have been bad because look at it, in light of the law existing at the time. But post 1928, in the 1945 schedule, you can't rely on the use of force. That would have any consequences we should bear. Now, finally, very quickly, well, sometimes again, look at the, just want to quickly, Arab-Israeli conflict. As you would know, in terms of territory, Israel had a series of wars between the Arabs and the Israelis. 1948, 1956, 1973, did we have any after 1973? I can't remember. And in every instance, the Israelis were gaining territory. The Arabs were conquered. So if you like, what used to be Palestine is getting smaller and smaller and smaller. And bear in mind, in 1948, the UN had come up with an initiative to have what was then partition. You would have an Arab section and a Jewish section. The Arabs did not accept it. So they're still fighting today. But they are the great losers. I suppose it's a little difficult because, of course, as it's just Palestine, Arab territory. And they were called upon, if you like, to give up their territory. With the benefit of hindsight, we can see what it was probably the best decision than the other two. But if they had accepted it, and then, of course, they would have had much more territory than Palestine would never have. Because where are the Palestinians? Only Gaza Strip, and the West Bank. River Jordan. Because it's very violent. It's a tiny strip of land. That's why they say the strip, the Gaza Strip. But dense, very densely populated. And even if you were to give maybe a Palestinian state, I think it would be barely viable as a state, because a lot of the land have been lost. Now, Israel in all its wars, especially in the 67 years, had captured a lot of territory. They captured Sinai, that had belonged to Egypt. They captured the Golan Heights, that belonged to Syria. They captured the West Bank, they captured no. The Sinai is separate, because Israel and Egypt signed a peace agreement. Egypt said at the time we took Isaac, we said one thing, we want Sinai. So Egypt is no longer an enemy. They recognized Israel. Israel gave back the Sinai to them, and everything is okay regarding Egypt. So Arab-Israeli thing and Egypt is out of it. Syria never reached any peace deal with Egypt. So the Golan Heights, Israel is still occupying the Golan Heights that belong to Syria. And the West Bank, as you know, is always in trouble. The West Bank and Gaza, Hamas. But they occupied, what's the status in law of this occupied territory? It's a war. Israel is in occupation. But the real thing is occupied territory, like belligerent occupation. But they are not really a part of the territory of Israel. Under international law, they're not. And Israel, in bringing in people to settle on these territories, is doing something illegal under international law. Because you're not supposed to be set, it's not yours, is it? To be set with the land. But, and this is the other thing too, you've done international relations. And you know a lot about the realist theory, don't you? Probably in time, you simply just have to accept that as a fait accompli. So putting lots of Jewish people in what happens. When the time comes, if the time comes, are they just going to remove them now? I think Israel is busily settling because they want to ensure that those territories that will remain. So if you like, making a settlement even more difficult, like putting people in this place. So strictly speaking, it is occupied territory. And we still refer to it as occupied territory. And indeed, Israel itself has not really annexed this territory, say it is part of Israel. But it is establishing settlements in Israel. And that creates a problem. But that is over territory. And then, of course, at the point where the people in Palestine, observing and following this particular conflict, Palestinians say they have the right to return. Right to return. Whereas this was Palestine, what is today Israel? Israel said, no, you can't speak of right to return. We, as Jewish people, and what is even difficult about everybody, and this one I don't know if it's occupation or prescription or whatever, this is out of the one. In a sense, they all go to their holy books to show that they have rights. In supporting the claim, the Arabs will go to their holy book, the Quran. The Jews will go to their holy book. The Torah. Torah. Thank you very much. The Torah. Jews go to the Torah. Arabs go to the Quran. So this is our land. This is the holy site for us. It has been so for thousands of years. But guess what? They all claiming it for that common lineage. Abraham, they all descendants. Abraham is our father. He was our father. But you see what caused it? What created the problem?
Glory.
Glory is that Abraham had more than one wife. He had Sarah first. Yes. Sarah had Isaac.
So but he has had before Sarah, he had Ishmael.
Yeah, Ishmael before Sarah.
Ishmael was his
Sarah couldn't have children, so she sent him what do you call it? Yeah.
Yeah. Sorry.
This is your story, I recall it.
Yeah. That's right. So one on the side of Ishmael, other on the side of Isaac.
And the Muslims have
Both,
their part.
both Abraham for the same thing. So this is what makes the problem so attractive. Land river territory, holy sites. So both sometimes claim the same area, the same territory as their holy site. Their forefathers live there. So how do you say? This one is not prescription. Well, because in a sense it's prescription, they're always there. But there is this religious dimension. So that is with respect to the occupied, not part of the territory of Israel. Israel hasn't, so far hasn't said it's going to annex them. But in actual fact, it's almost as if it is doing so by establishing the settlements. In a sense, presenting us with a faith accomplished. And the rest of the international community will become realist. What could you do? But Israel doing it. Just settling. No more new settlements. Yes, we can have new settlements. Yes, well, saying that we've gone to peace talks, now we're trying to get another round of peace talks started. Maybe we should refrain from new settlements. But you can't continue getting out of that. Anyway, then you have this issue of secession. Now, this in a sense involves territory too. We have one state. Yes. I don't want to use it as an example, but I'll use it as an example. Close to us. Say we have a state of Trinidad and Tobago, 2 islands. And let us assume that the people in Tobago say we're tired of these treaties. They're passing a budget, and they would not give us what we consider to be our fair share in the budget.
Yeah, but
That's right. We are tired of this thing, so therefore,
very tired.
best for us, just as how Grenada, St. Vincent, and these places, they have their own independence. We want to go independent. Other state says, no,
They're going to try that sometime years ago.
No,
don't. They've been threatening it.
I believe
there was they never
Talk
did
about
it.
it.
Yeah.
Quebec in
Quebec,
Canada has been trying to do this for a while.
That's right. You have all these kind of secessionist sentiments. And the country now always resisting it, saying, insisting on the territorial integrity of the state. And they say, you try it, we would be willing to resort to arms to make you stay within the federation or within the union, whatever it is. Yeah. Secession. But sometimes some secessionist movements are successful. India, all Pakistan was once part of India. Pakistan, Bangladesh, they were all part of India at the time of 1947. But then there was partition, the Muslim part, Pakistan. The Muslims didn't want to live together with the Hindus, so they had their own state. Yes?
Angola separated from St. Nevis.
Oh,
Angola separated.
that's right. Right here in the region. Thank you very much. Just to be Antigua. So, not Anguilla. St. Kitts, Nevis, Anguilla. That's what it is. 3 islands. And Anguilla seceded. So you have a separate, it's a colony now. If they had remained with St. Kitts, Nevis, they would have been independent. So they are colony. They just didn't want to be part of this arrangement. Secession. India split into Pakistan. Pakistan later split into Pakistan and Bangladesh. What today is called Bangladesh used to be Eastern Pakistan. But between the two, between the East Pakistan and the West Pakistan, you have a large tract of Indian territory. So you have Indian territory separating into the East and the West. But the East always felt they were getting the dirty end of the state. They were not happy with the arrangement, and therefore, in the mid-1970s, there was a war of secession. They won, and therefore, today you have an independent Bangladesh. So that is happening sometimes. States there. Breaking up, you had Yugoslavia, the Serbs, today we have a state called Serbia, Croatia, Bosnia, and these places. So you had one state, one federation, and then afterwards, the same thing applied with respect to the Soviet Union. You had Russia, you had Uzbekistan, you had Ukraine, you had all these Latvia and Estonia and all these places. Today, where you have one, you have many. Again, secession. So when you had the Soviet Union, you had one state comprising, extending all the way to Central Asia. A big Russian demands fast. And then you had these Central Asian states. So they have these new territories, new states. Okay, as is simple. And of course, you have other cases. Ethiopia, Eritrea used to be part of Ethiopia. Today, of course, we have an independent state. And the last one I'm aware of is South Sudan. We have Sudan, one Sudan, and then the southern part, the northern part, the Arabs and so on, and the southern part, we have maybe the Africans, they have seceded. But most of the oil is in the south. Secession, so this can happen. Or it could be in a colonial type situation where countries fought wars of independence to free themselves from the colonial yoke. And then, of course, you have countries like us. I mean, as I said, to be sovereign, independent countries. How did we become sovereign, independent? We were colonies. We were not states. Trinidad and Tobago became a state on the 31st of August, 1962. What is the situation? We were colonies. But how did we become a state? Why did we become a state? Don't look at me. Why did we become a state?
We negotiated.
Exactly. Our leaders left Trinidad. Just give me. You have to leave now? Okay. Okay, I'm just wondering. And in any event, you will already so I submit you. 1962, our leaders left here, both government side, opposition side, Dr. Williams, Woodrow and Capilio, and they went to London with the colonial office, sat down, negotiated. So we say, yes, we're satisfied, all right, Trinidad and Tobago would be independent. And then, of course, so in a sense of that, it was a constitutional treaty more than anything else. Through constitutional means. If we had done it by force of arms, and some countries it would have been by force of arms, but it was through constitutional means. And I think sometimes when the British used to pass, enact legislation, so therefore we succeeded to the British. And of course, very important, our new status, independent status, because in international law, to international relations, recognition sometimes.
So what is still getting?
Recognition begins. The new status was recognized by other states. So when we had our independence, many countries would have sent their representatives to our independence celebrations. The British themselves would have sent their representatives, which member of the Royal Family of Cape, would have sent member of the Royal Family, then you would have had a number of ambassadors and so on coming in to attend the ceremony. When I'll be raising, and people will tell them, oh boy, just to look at the Union Jack McLeod and the red, white, and black, going on, moving more.
It's not like yours there. Yeah.
Well, no, I wasn't here. I was there when I was around, but I wasn't there. I mean, I was in the day.
But it was a reenactment of it.
Gary said.
It was very okay. So, but this is the idea that this is how Trinidad and Tobago came to the sense. So this new territory that was then British became the territory of Trinidad and Tobago. And we have now one aspect to the boundary issues. Sometimes you have states, and you have problems regarding the boundaries. Where the territory of one state ends, and that of the other begins. It's problematic sometimes. Well, especially to take, well, let's take first of all, go back to the 19th century, when most of the Latin American states gained their independence. You'd have had problems regarding boundaries. There's a number of what used to be provinces under the Spanish colonialism became independent states. So where would the boundaries? If you have, say, for example, in Chile and in Argentina, where is the boundary? the practice adopted by Latin American countries was that they would use, because of the states of administrative provinces, so they would use the same boundaries as the Spaniards used to delineate the boundary. So what was before an administrative boundary would now become an international boundary. We wouldn't change the administrative boundary. Okay, Candia?
Right.
And this doctrine we refer to as the Uti Possidetis doctrine. UTI, POSSIDETIS.
What is UTI?
UTI, there you go.
Okay, I'll go slowly for your sake, only for your sake, UTI, one word, POSSIDETIS. Possidetis.
Okay. Doctor.
Later, when the African countries, in the 1960s, became independent, they adopted a similar position. We would keep the boundaries as they existed in colonial times. Now you're looking at me and shaking your head and say, good. The advantage of that is that the new country is starting life in a fairly stable condition, with its boundaries determined, ascertained. However, it wasn't always as orderly as that, because you have sometimes, because of how the colonial powers sometimes drew the boundaries in a very arbitrary manner. And you have people sometimes at the wrong side of the boundary. So to give you an example, to take Somalia for example. You have ethnic Somalis, say, in the north of Kenya. So they ethnically they are Somalis, but they're within the border of Kenya. You have Kenya and Somalia, Somalia and Ethiopia would have a similar problem. Ethnic Somalis on the Ethiopian side of the border. However, the African Union, before it, the Organization of African Union, took the position that we're keeping the boundaries just as. So they did have some anomalous situations, probably could have created some hardship because people were not with their, in some cases, some minorities were not with their kin and kin. But so be it. Because if you want to attempt to engage in an exercise to withdraw boundaries, you just didn't know where the whole thing ended. So if it does produce some results, unfavorable, but of course, we think it better to have this arrangement rather than to try to withdraw the boundaries state to state. Because there are so many of them to be withdrawn. Drawing boundaries is not always a very simple exercise, because sometimes it concern people. So you might as well, if an idea, well and low. I think we will stop here. Thank you very much. I took some of the time, but I'm not feeling too guilty because I'm not feeling too guilty because I think I have taken back my half an hour. Wow. Is there anyone who wasn't signed? Have you signed the register?